I'm of, of the opinion that the decisions of the courts have in no way adversely affected the prosecution of crime.
Chief Justice Earl Warren had been a prosecutor and attorney general and governor of California before he was appointed to the Supreme Court by President Dwight Eisenhower in 1953.
Earl Warren had actually pretty good law and order credentials. People have a lot of different views of the Warren Court, but one way to think about it is as a court that was very concerned about fair process.
The perception was growing that too many convictions weren't being obtained justly.
So in the 1960s, under the leadership of Earl Warren, the Supreme Court began to say to the states, we're not going to take this hands-off attitude anymore. We're not sufficiently confident that the procedures state courts are following and state police departments are following are actually fair enough.
The Supreme Court handed down some controversial but important decisions that forced the states to comply with the Bill of Rights. In March 1963, the court ruled in Gideon versus Wainwright that everyone has the right to a lawyer at trial, whether they can afford one or not.
I think people now would be surprised to know that there was a long period of time in the nation's history where somebody could be made to go to trial without a lawyer.
The key word is trial. The Sixth Amendment gives everyone the right to counsel in all criminal prosecutions, which everyone assumed meant in court. But in a case called Escobedo, that's how it was pronounced in court, Escobedo versus Illinois, the Supreme Court recognized that suspects needed lawyers even before their case came to trial. But how long before?
If you don't have the right to counsel during police interrogation, then your right to counsel at trial is meaningless. You've given the entire thing up. You've given it away. There's nothing for counsel to do at trial because you've confessed.
And in Escobedo, it had been established you had a right to counsel when you had become the focus of the investigation, whatever that meant.
That had created a lot of confusion.
The right to counsel is a Sixth Amendment right. The right against self-incrimination doesn't come from the Sixth Amendment. It comes from the Fifth.
Nothing in the Fifth Amendment mentions having a lawyer at any of these things.
Before Miranda, everyone thought the Fifth Amendment really only applied at a trial or at one of these.
I respectfully decline to answer on the grounds that my answer might tend to incriminate me.
In fact, invoking the right against self-incrimination came to be known as taking the Fifth. The lawyers present at a trial or these hearings understood they had to respect those rights, but no one thought this right applied to the interrogation room, when lawyers weren't around, but where most confessions took place. And the Supreme Court hadn't cleared up another area of confusion. The only way to tell if a confession is voluntary was to try to get in the mind of each suspect case by case by case.
The exact same question kept coming before them in these confession cases. Is it voluntary? Is it not voluntary? Is it voluntary? Is it not voluntary?